I'm one of the lawyers at the Family Law Project. So today in this conversation series, we're going to keep it just that, pretty conversational, and we're going to be talking about family dispute resolution. So what we're going to talk about today is family dispute resolution, when it might help you resolve parenting or property matters, keeping you out of court, the benefits, different types of mediation. So that's the sort of info that we're going to go into. I'll introduce now and I'll bring in, and hopefully my technical difficulties have improved. Oh, there we go. So this is Temara Willis. Thanks so much for joining us, Temara. Appreciate it.
Thank you for having me. I'm looking forward to the webinar.
Great. So, Temara, those that don't know you, you're a practitioner. You have assisted over 2,000 clients in mediation, family law mediation, and you own the Adelaide Family Mediation Service. Can you, we'll just go straight into it, tell us a bit about how you got into it and what family dispute resolution is?
Yeah, thank you for that. You're right, I'm the principal mediator at Adelaide Family Mediation, which was established back in 2018. I had a bit of a different background leading into mediation, and I worked actually as a general manager of human resources, and I'd done that for many years. And I really wanted to, I wanted to pursue a different career. I had been through mediation myself when I was in my late 20s when I was going through a divorce, and I saw how valuable that service could be, and I really felt some of my skills were quite transferable into that space. So I was lucky enough to be able to do some postgraduate studies back in 2017 through the Social Relations Institute, through Relationships Australia. I was able to gain that qualification, and then slowly and surely I built the business up from there, and then about 5 years ago transitioned full-time into the business. And since then we have had over 2,000 clients through and providing them support with FDR. We also do other sorts of family mediation, not just with separated or separating families. We support other styles of mediation as well, but primarily that we do FDR, and very, very proud of where we've got to, but also I'm very thankful that we've been able to support those clients throughout the years.
Thank you. And if anyone can just drop in the chat box, can everyone see Temara, or is it just me who can't and the video's gone off? I didn't want to interrupt you, Temara, during the chat there. Just wait. Okay. Oh, okay. Kimberly says she can see us both. That's interesting. It must be these technical difficulties. Oh no, there we go. I can see you again. Great. Thank you. And that's why we call this the conversation series, because it is informal. And you mentioned there actually Relationships Australia, where you did some training. In this poll, we've asked everyone who they are essentially, and I can see a third of the people that have joined today are themselves FDRPs, or Family Dispute Resolution Practitioners, for those who are not. So thank you for those people that have joined us. Not sure you'll get a lot of value out of today. You should know it all. We'd love for your contribution though, so feel free to add anything in the chat box as we go along, and you're welcome to stay, of course. So can you tell us actually on that FDRP, or a Family Dispute Resolution Practitioner, what is the formal qualification that you need to do it? Because not anyone can just go and start a mediation service, can they?
No.
Or can they?
Well, anyone can start a mediation service. If you want to do mediation with families as an FDRP, there are certain qualifications that you do need to achieve. They're actually making some changes to that at the moment, but generally it's a postgraduate qualification in Family Dispute Resolution. You must also be registered or meet certain standards with the Attorney General's Department, and you must be listed on the Family Dispute Register. And so there's some of the steps, and that's obviously to make sure that the profession is safeguarded and that the parties that are part of that process are meeting with people who have the qualifications to perform that task. So it is a little bit different than just mediating with, you might get you might be accredited as a mediator, but being an FDRP is slightly different to that.
And when you've got that hat on, or when you're in that role, you're not giving legal advice, are you, to parties?
No, as a mediator, even if I was a family lawyer by profession, which I'm not, but as a mediator, during performing the role of a mediator, you don't provide any legal advice. You can definitely provide legal information, and we do that, but we don't advise clients. Our role is to support both parties in trying to reach a self-determined outcome, and information is important as part of that, but we don't advise them a legal position. We would always encourage parties to get legal advice if they haven't received legal advice, or do some sort of research. Some parties can't afford legal advice, but there's definitely options available, and we can provide referrals if clients need that, or there's definitely a lot of information out there online that they can look into and make available to them. But no, we don't provide any legal advice during mediation.
And when you give legal information or procedural information, I know a lot of people that I speak to are worried about the media, and I'll just say mediator for today's purpose so people can understand that mediators perhaps aren't impartial or independent. Can you reassure everyone about that?
You know, I do find that when you perform the role of a mediator, if a client does raise concerns with me about impartiality, usually I find that the other client would also feel the same. It's we do perform, we are independent, and usually in all cases, we wouldn't have had any dealings with clients before they engage our services. And so our role is to provide an impartial support to clients. Our role is to facilitate communication between the parties, trying to get them to self-determine and reach an outcome that they're wanting. We help identify the key issues. So what's important for the parties to talk about, what information do we need to focus on during the session. We help manage the conflict that they're experiencing, so we keep discussions on track. How do we remove any of the tensions that they might be experiencing? Most importantly, we promote, if it's a parenting matter, focusing on what's in the best interest of the children. And we do that with both throughout the whole process impartially. I think that sometimes when parties are experiencing a high level of conflict, that they're concerned about the information. They get information from a lot of different people, and that can cause them to have questions about the mediation process. But I know that our role is to provide support to parties to help them self-determine, not pressure or coerce them into reaching an agreement that they might not feel comfortable with, but really just explaining, like you said, the information. And we do that in a really consistent way. So the information that I provide to the parties is the same. And when I run through property and financial information that they need to know, I make sure it's consistent with both parties, as well as what the courts consider regarding what's just and equitable, the needs and contributions. And then with the parenting matters, we talk about what is in the best interests of the children as defined by the Family Law Act, and I make sure they have that same information. If we provide referral details, we make sure that both party has an option to have any referrals that they might need. And then if we provide referrals to lawyers, we make it very clear that we're not aligned with any legal practitioner, but there's some services available out there, whether that's legal services or whether that's a private lawyer, but that's just generally, and we provide both parties with the same level of information, and that's how we try and be consistent through that.
And you also do at the outset what we know as an intake session. Can you talk to everybody a bit about that?
Yeah, I think the intake session for me is, I kind of refer to it, it's the intake and assessment. I refer to it as a pre-mediation. And I think it's a good opportunity. That's where we get to know parties. We get to understand. There's certain things that I, as a practitioner, need to know to make sure that we can determine mediation is appropriate for their matters, and that we can provide a safe environment where we are going to mediate the matters. But we do provide the same level of information in that pre-mediation that we would to all clients, so they're really clear around the process, what's involved, how it's going to work, what information they're going to receive, what information they need to be aware of. But it's a good opportunity for us to get to know the clients, make sure mediation's appropriate, make sure that there's the same level of information to both parties. Some parties have legal advice before they come in, other parties do not. And so we want to make sure that both parties have the same level of information or same awareness around some of the considerations. And so that's a good opportunity to do that. And then the most important thing that I think with the intake and assessment for me is that we ask parties whether they're here to participate with a genuine intent to resolve the matters. And we expect both parties to say yes to that. And that's why then we agree to take that client on. If there's concerns with a genuine intent and whether parties have further questions or they're not quite sure, then we once again have an opportunity to delve a bit deeper into that and make sure mediation is going to be something that both parties are going to engage in and participate in effectively, as effective as they can.
And that was actually one of my questions that leads nicely into, because I was going to say, because mediation's not compulsory, is it? You can't be forced to participate.
No, mediation isn't compulsory, but in many cases it is a required step, especially if there's a parenting matter and you might need court orders. So under the Family Law Act, when it comes to parenting matters, there is an expectation that you will try and attempt to participate in family mediation. There are some exemptions to that, and the mediator works through that with parties. And for example, if there's concerns regarding family violence or any child abuse, if the matter's urgent, and requires the matter to be, heard straight away, or if there's a party that's unwilling or unable to participate in mediation, then there can be some exemptions. But with property and financial matters, it's highly encouraged, but it is not mandatory. But the courts do expect that the parties have at least attempted to try and resolve some of those issues before they do start those proceedings. So it isn't compulsory. We always make it very clear that parties, it's voluntary. You've engaged with our services voluntary. You could choose to engage any practitioner that they've engaged with us, and then also that the process is voluntary, but there is an expectation under the Family Law Act that they do participate if it's to do with conflict over parenting matters.
Do you have many matters where you make the assessment that it's not appropriate for the mediation to go ahead?
No, we more often than not, nearly all matters we would deem appropriate to move forward, unless a party has really raised concerns with us. So as long as we can provide a safe space and a safe way to allow them to participate in family mediation, we will provide those services. And unless like I said, we've met with a party and they're not genuine about engaging, we don't want to waste parties' time and money by participating if someone has made it clear that they're not going to participate with a genuine effort, or if the safety concerns are so extreme that we cannot provide or are concerned about the provisions of a safe service, and we won't provide it. But most often we will work with parties to figure out a way that we can provide services for them in a safe way if they're willing to participate in those services.
Thank you. And Temara, a few people have commented that you've frozen, and then I can see a whole heap of reports have dropped in the chat box, which everyone can ignore. That was from our last conversation series. For some reason, this platform has been working really well, but this morning has decided to do all sorts of crazy things. So I suspect that your freezing might be the internet connection your end. So I know that we've had storms in the last day or two in Adelaide, so I'm not sure if that's causing it, but we'll carry on because everyone can at least hear you very
Okay.
well. So,
I hope I haven't frozen with like a really terrible angle, which is probably going to be my luck.
Oh, look,
It
it's
says
not
here
the
that
best, but
signal's good, but you are right. It kind of jumps in and out between signal excellent and signal not great. So
okay, no problem.
I'll keep going.
We'll carry on.
Apologise for my freeze framed.
But the content is really useful, I think, and I'd really enjoying that. So thank you. I was actually about to ask a bit more, and Elise in the chat box has also mentioned the Section 60I certificate. Can you explain to those? Because I know online there's a lot of chat about Section 60I, and I'd get clients calling me asking me if I can give them the 60I. You know, it's that I'm sure your office does as well. Can you tell us a bit about the 60I?
Yeah, well, a Section 60I certificate is a document that is issued by a family dispute resolution practitioner in Australia. It shows that you've attempted to mediate in FDR, and that's what's required before applying to the family court regarding matters. So it has different criteria around whether parties have refused or unable to participate, whether there's an exemption, so whether the practitioner has decided that mediation is not suitable to move forward based on those pre-mediations that we talked about, whether we've commenced mediation and we've decided it's not suitable to continue. And so the mediator will work with participants. We now issue that individually to clients, so both parties would receive their own certificate if they were part of mediation. And so that's a document that we provide to parties regarding parenting matters and to demonstrate really that they've attempted with a genuine effort, or if they haven't been able to, why they haven't been able to participate.
Yeah, I had one last week, and the mediator checked the box with the other part, well, in relation to the other party not making a genuine effort, and that's because they stormed out of the room.
Yeah.
Yeah.
It does happen.
Yes.
That's rare, but yes, sometimes that can happen.
Yeah, unfortunately, that was a court-ordered one. So like you said at the outset, you really want parties to genuinely want to be there, whereas with some of the court-ordered mediation, there's sometimes some resistance.
Yeah, and we, it's not that if someone says I don't have a genuine intent, we just say, okay, well, we're not going to mediate. We work with them and we try and educate the clients to the benefits of trying to self-determine versus an independent party, a judge, making a decision. They might hear the matter for a day or two and then have to make the decisions regarding where the children go to school and how much time they spend with the parents. And the judge don't want to be in that position, and clients usually don't want to be in that position where someone independent's making those decisions. And we try and work through that. And we understand it's very difficult, and mediation isn't a magic wand. It still requires collaboration and compromise. And so we try and work with clients to understand that and understand that if we are unable to reach a resolution in mediation, then that provides the only options left then for clients is that they are still in a state of conflict, so there's no resolution for them or for their children if it's parenting matters, and for the other party, or they need to litigate, and neither of those are great outcomes. And so we try and work with clients to understand that and to help them feel that they're empowered through that mediation process.
One of the questions we've had or comments is someone who has a 60I certificate, so I'll just talk on this while we have been, that's expired, because they last for 12 months only, don't they?
Correct. So it's last attendance or attempt at mediation, and it's 12 months from that date. And I would always, I'm not sure around the thinking behind the 12-month period, or how that came to be by the people who put the legislation in place or the laws in place. But I think it's 12 months later would be another good opportunity to try and re-engage in those services. If it didn't work last time or someone refused to participate, it probably wouldn't hurt to try that again. Because that is a significant period of time, and you never know, things might be different 12 months later, and so that could look different.
particularly in parenting matters, because children of any age, their lives can change so much in a 12-month period.
When I started as a mediator, I was of the assumption that all my clients would be newly separated parties.
Yes.
So I started out thinking that I would be meeting with, I understood a lot of emotion. People would be off on the back of separation, which, I'd been through that before, and I know how distressing it can sometimes be, and working through that. But what I've realized straight off the bat was that a lot of my clients, I would say at least half, if not even more, have been separated for long periods of time. And so it's not people who are just starting out that co-parenting journey or trying to sort out their property and financial usually is in the first couple of years. But with parenting matters, we might have parties that have been separated for 10 years, 5 years. They might come and see us, and then 3 years later we get a phone call saying, look, we've got this issue, we need to come back and talk about things. And I always explain to clients, mediation, it doesn't mean that you're not a great co-parent and that you're not doing an amazing job in co-parenting. It just is another level of commitment that you want to co-parent so effectively that when there's issues or there's any dispute or conflict, you're wanting to engage support to help you through that. And that shows how important the best interests of your children are. So and clients understand that, and that's why we do have clients that come back, yearly or every couple of years if something arises, because it's just that opportunity to get things back on track if things aren't going, or if there's some changes that need to be made. And I think it shows the level of support that they've got for the other parent as well as for their children.
Yeah. So I wanted to ask separate parenting questions, and then we'll talk about property. But in terms of parenting mediations, how can parents best prepare for that, and what type of things can they discuss and agree on in mediation?
Yeah, I think best preparing, we usually send through a things to consider and a preparing for mediation workbook leading up to mediation. But to best prepare, I think it's writing down a list of all of the things that have either created conflict or have the ability to create a level of conflict, or for things that you've already agreed on as a co-parent with the other person that you might want to revisit and include into a parenting plan with the other party. Understanding getting some legal advice and understanding their legal obligations and legal rights through the process. Speaking with people and making sure and kind of reality checking what they think is important. And then just making sure that they're focused, to best prepare, make sure they're focused on moving forward. So it doesn't mean we don't consider things that have happened in the past. How do we address those things that have happened in the past, but with a view that we're going to address those things so the future arrangements work best for everyone involved.
And you'd have, I'm guessing, this conversation with parties in their individual intake sessions beforehand to help them, their mindset prepare?
Correct. So, we ask a lot of, why questions. Why is that in the best interest of the children? How do you think the other party is going to see that? Why do you think they might have a different view on that? What are some other things that you might want to consider? So what are multiple solutions that you think you could outside of just that one solution? Are there others that may be something that you might want to consider? And if not, you might want to have a think about that before we come in. And like I said as well, we do explain to them what's in the best interest of the children, and sometimes that information is useful as well. A lot of parties will come into mediation and say, upon reflection from that pre-mediation, I now see it a bit differently, or I'm prepared to discuss that a bit differently. And we use some examples for parents to help them on that journey of really exploring some of those issues. And we try and make it not specific to their matter, but just some general kind of examples of how parties might see things, and that helps them along with preparing the best way that they can.
And I guess a lot of those thoughts, reflections would be similar in preparing for a property matter as well.
Yeah, definitely. I think with property matters, the only difference there is like I said, there's different levels when people come to us with the information that they have. And so I think with property matters, it is a lot more structured, I find. We do use quite a lot of visuals. We put it up on the screen so everyone can see the information that we're working through. So with the property and financial matters, we do also send a client checklist beforehand, informing clients and their obligation for disclosure. We provide that level of information, and we take them through that in the intake, so they understand their obligations, and we provide that level of information. But I think mediation for property and financial matters is good to, in the first stage, create a level of awareness, make sure the parties have that information, and that they're starting off with what they need to be aware of. It's a good opportunity. Sometimes parties are well and truly into discussions regarding proposals, but sometimes parties aren't. They're not even clear on what the property pool is. And so it gives us an opportunity to go back to the start. So what is the property pool? So first of all, what the courts consider just and equitable, and what are the contributions that the parties have made and their future needs, and how that plays into it. But then an opportunity to clarify the property pool, reach an agreement on the value of the assets and liabilities. Even just getting that done in mediation can be a huge cost saver for clients, even if they're not able to reach an agreement overall. But an opportunity to explore the needs and contributions that they have made, and they can do that. They're not waiting for weeks and weeks for responses. You're doing that in the moment, and you're being able to ask questions and get responses. And then hopefully in a position to negotiate a just and equitable division of the assets based on the needs and contributions, but as well as the needs and wants of the parties. And they're the things that we talk about in mediation. So, and then
I often refer, if a client's sort of at the early stages of a property settlement or needs that financial input, I'd often refer them to mediation at the start, to at the very least be able to talk through and agree on, this is the asset pool, these are the values of the assets,
Yeah, and we could, sometimes it's a 10-minute exercise. Other times it will
not always
an hour exercise, just working through how people determined value, whether there's an agreement, whether other ways to determine a value needs to be agreed to. Some parties agree to use Red Book for vehicle, other people want to use car sales, regarding the value of the home. Sometimes people come without even an agreed value on that, and they need to mediate how they're going to reach an agreed value on a home. And so we work through that. But ultimately, like property as well as parenting, the end result, if we do reach an agreement, is documenting that for the parties. So we provide, for financial and property matters, we provide them a worksheet, which is their different proposals to each other, as well as the agreed position, all the assets that have been agreed. And then we also provide a heads of agreement if they reach an agreement. So it's documented, and that information they can take back to a lawyer or use that information to do a do-it-yourself consent order. And with parenting matters, it's the same. We send through a draft parenting agreement, and then they've got that kind of framework on how they're going to agree to co-parent moving forward with that agreement. And then hopefully, if they're happy with that, we send it for signing.
And that's a good leeway actually into discussing the fact that everything discussed during mediation is confidential unless there's a written signed agreement. Can you talk through that a bit?
Yeah, so mediation, I think that's one of the benefits of FDR. It's something that is unique to the process. So if you are doing FDR with an FDRP, a lot of acronyms, but like you said, a lot of people will know what that means, or hopefully by now anyway. The discussions are confidential and generally can't be used as evidence in court unless there is a signed agreement, a parenting agreement at the end of that. And so that gives you the option. It gives parties the ability to talk about what's important to them openly and honestly, and not fearful that that information or proposals may be used in court, and they might be more willing to agree or accept or discuss things, knowing that there's that level of confidentiality that's provided to them.
I find it makes clients more open to have discussions that they might not otherwise do. They just feel a little bit more confident knowing that they're not going to be bound by these proposals or these discussions, but it's just sort of getting ideas out on the table.
Correct. Yep.
Child inclusive mediation, is that something that you do?
We do child inclusive mediation, but there's some certain criteria that needs to be met with the child inclusive mediation that we do. So children need to be of a certain age, and they need to be willing to be part of the process. We make it very clear to parents that the child inclusive mediation isn't about the children making a decision about what they want. They're not the decision makers, but they're going to have a voice, and we're going to share that information back with the parents to help inform them to make a really constructive decision about what they agree to moving forward. And so yes, we do it, but only if it's appropriate, and usually children need to be year 6 or above, and no concerns that might take place with their involvement. Both parents will need to agree to it, and then we send a confirmation email to the child that's participating and explain to them what's involved, and seek their agreement that they're happy to be part of that process.
Yeah, I know not all mediation services have someone who's qualified to do that or willing to do that. Probably, I mean, what do you think about maybe half of the mediation services offer the child inclusive service?
I would say even less.
Less,
than
yeah.
half. And I think it's well, because it's quite specialised, I think you need to. So I did some studies with Children Beyond Dispute with Jennifer McIntosh, and to get the skills to be able to perform that. But I think if you're working with very vulnerable people and children, there's certain things that you need to do to be able to work with children, and I think that a lot of there's a lot of amazing practitioners out there that do it, and there's a lot of people that specialise working with children. And so that's where we would refer to if we had children that were younger, or there were concerns, about the children being involved in the process. We would want someone who works predominantly with children to be able to work with them.
I've also had experience with service providers who are not so good in that respect, and I don't think there's really sufficient standards required to be able to do that work, which is a bit disappointing. I'm not sure if the government has intentions to change that or not, but certainly in my experience it can be a bit hit and miss in terms of the quality of practitioners doing that work.
Yeah, and you're right, it's not, there aren't any there's some best practice principles in place in that space, but there's nothing that dictates who can and can't do it as yet, but I'm sure that will change over the years.
I think it will. I agree. Bit of practical information. Do you do any MS Teams intakes and mediations or shuttle conferencing?
Yeah, we use Zoom, but it's the same, like a platform.
Yeah, same thing.
We always encourage, where possible, for parties to come into the office, and unless they live remotely, we've had clients from overseas where they just can't come into the office, and so we can provide different ways of being able to facilitate mediation. I think COVID's changed the way that everyone looks at accessibility to things, and some people are very comfortable. We give parties the option to come in or do it remotely, but if they're based in Adelaide, we would kind of want to understand why they wouldn't be able to come in and engage in services face to face. But we provide the option. We also do teleconference. Sometimes it can, it makes it a lot easier for people who have mobility issues, or there's issues getting into the city, and we understand that, and there's no issues with that. With property and financial, it's obviously a lot easier when you're in the room and you can see the screen. When we do Zoom, we do share screen, but it's a bit smaller and it's a bit more difficult for parties to work through, but we do offer those services. And with shuttle mediation, we would do a lot of shuttle mediation. So if it's high conflict, if a party's got safety concerns, if we start mediation and it escalates for whatever reason, we might think it's more appropriate to do shuttle. And so we will, we've got different office spaces where I then walk in between, providing those services. And that can be really effective as well. So shuttle mediation, I believe, can be, especially if there's a lot of emotions, it can be really useful, and it can actually be a time saver, even though it's,
Yes.
to the parties individually, it can actually be really productive. And we do a lot of that. Whenever we do legally assisted mediation, it's shuttle mediation as well.
And I was going to get to that question actually, Temara, is the difference between mediation where you're self-represented as opposed to when you get, us lawyers involved. So you do both. Can you talk us through the differences there?
Yeah. So it's only if a client nominates that they want to do legally assisted mediation, and they might have a lawyer, they might feel more comfortable with the lawyer being present. And so we accommodate that. And I would say probably 10% of our matters are legally assisted, and 90% would be self-represented. Having a lawyer part of the process can be extremely beneficial. Don't
we make it more difficult for you?
Rarely, sometimes, yes, but predominantly, and most of the time, I would say that having a lawyer there, being able to provide legal advice to clients in the moment, can actually be very beneficial. I've met some amazing lawyers who they've got a real authority with their clients, and that helps, and they know that the lawyer is advocating in their best interest, and that concern that you said about impartiality and neutrality, being neutral, they know they've got someone there who's helping bounce things off with them, and they can provide some really useful information. They can calm clients, explain to them what's going on, and help them come up with those different solutions that they might not be thinking about if they didn't have someone there supporting them. Sometimes lawyers can make it more difficult if they're
litigious.
Yeah, if they're litigious, or if they're not really focused on, why parties are mediating, to save the costs and to self-determine, and they're set on certain things that may not be as important to the whole process, but more about kind of having a certain outcome for our client versus what may be in the best interest for the whole situation, but that would be rare.
I find personally, I like to be involved in mediations for my client where there's a bit of a power imbalance, to ensure that they're getting the correct advice and not feeling pressured into an agreement that might not be one that's best for them. And I think shuttle conferences and or lawyer assisted can assist in that respect for where there is that power imbalance.
Definitely. And we would always encourage clients as well that if your lawyer, you can't afford for your lawyer to be there, or it's not practical, that you speak with your lawyer at least about trying to maybe be available to ask some questions throughout the process. So, do they need a minute to check in with their lawyer and run through anything with them if they've got any questions or concerns? But we also don't get any parties to sign anything on the day. So they can always stay and speak with their lawyer if they've got any questions or concerns, and they can run through that, and then we can talk through any questions or concerns that the client has after speaking with a lawyer if that comes up.
But would you draft up, say, a parenting plan or a sort of overview of an in-principle property agreement, but without them signing? Is that what you do? Or
we draft it up. and then we send it to them, and then they can get some legal advice, but they don't sign anything on the day. So they're going to have a chance to review it, speak to their lawyer if they have one, financial advisor, people in their inner circle about what was discussed and what's been agreed to. And then if they've got any concerns, they can either come back and have another session or work through that with the other party, or we can try and work through that as best we can.
And how many times can people come back and use your service?
I don't have an end date. Sometimes we do let clients know that it might not be appropriate for them to return because we've exhausted where we can provide a level of support for them. But we usually, to be honest, most parties will resolve parenting matters in a session and property and financial matters in a session. I do find that with property and financial matters, parties usually want to come back, and we call it a follow-up. And that's really to, that they've had a chance to review everything, they've spoken to who they need to speak to, they've had a chance to think about timing and how that's going to work for them, and then responding to any of the proposals that were made to kind of formalise it. So there seems to be, with property and financial, we will go through the assets, the liabilities, reach an agreement on the property pool, talk about different proposals, and when that could take place, and then they go away, think about it all, come back and finalise it. With parenting matters, most people can resolve things in one session, but we've had, when there's a lot of issues in dispute or a lot of information to be shared, or where people are at different levels with their level of understanding of where matters are at, they might need to, they might take 3 sessions to get through all of the issues.
And might it be, for example, in a parenting matter, there might be an interim agreement that one person's going to go off and do a parenting course or some drug testing, or in a property matter, the parties are going to get the family home formally valued and then come back for more mediation once that's done?
So if that happens, if they're the sort of agreements that we reach, we will summarise that in an email. To the parties, that these are the things, this was the agenda items that were discussed, and these were the things that were agreed to as next steps. And then they have the option to return to further mediation, so they can contact us, or if appropriate, a Section 60I, or we book straight in. So it will be in a month's time we're returning, and these are the things that need to happen in the next month before the session takes place.
And what do you do in circumstances where there's just no agreement and it's very apparent that nothing's going to be agreed?
I think it's rare that you'll get no agreement on anything. However, yes, you're right, where it's very clear that mediation isn't going to be as suitable. I reinforce the options available to clients if they are unable to reach an agreement, and sometimes they're very clear on that and that they understand that, and that's fine. What we would always do is recommend that they consider a different mediation provider.
Oh yes, yep.
So not to give up on mediation in entirety. There might be a different style or a different practitioner or mediator out there that might be more suitable, or might get some sort of inroads into their matter that we weren't able to work with them through, or we ask them to take a minute, go away and reflect and think about everything that's been discussed, and then return, or we issue a Section 60I saying that they've made a genuine effort but have been unable to resolve the issues for whatever reason.
And in terms of different mediation services, as we kind of mentioned early on, there are some practitioners who've joined us today. So I'm aware that some work at government, such as Relationships Australia or Family Relationship Centres. Your service is a private service. Can you just give us a bit of an overview of the difference between the community or government-based services as opposed to private mediation services?
Yep. So I think that the role of the mediator is the same. It's consistent. The government, or like Centacare and Relationships Australia and those providers, ultimately the level of service and the mediation that we provide is quite similar. The difference between private and those public services is we obviously charge a fee for our services. I know sometimes government providers still charge a fee, but we charge a fee for the pre-mediation as well as the joint mediation. So there's a cost factor involved, but some of the benefits of engaging in services, we have clients that might have reached out to other providers or government providers, and the availability is just not there for them. So they can't get in within a timely like because of the wait list, or the flexibility that we can offer. So we do Saturday morning appointments, we do some evening appointments. They might not be able to take time off work, or or there might be issues with care of the children and things like that, which we can try and accommodate as best we can. So I think the difference between what a private practitioner offers and then government is we have a bit more flexibility with how we schedule our clients and the timing around that versus those other services.
That's definitely the main, I guess, concern that I have when I speak to clients, particularly new clients who feel as though, you know, the wait lists for certain services are so long. And it's really frustrating, particularly if they're not seeing their children, not spending time with their children. It can be really disheartening to have to wait, you know, 2-3 months to get into that joint session for a mediation. So that is definitely a very common concern. And
it definitely, if there's issues with being able to see the children, that can expedite the matter, but also it might be we need to talk about kindy and we can't wait 6 months for that process or 3 months. We really need to resolve the issues quicker than that, or the financial and property matters. They might, you know, they want to be able to schedule something and then again, you know, quickly after that process, and they feel that a private service provider might be able to do that more seamlessly than other providers, and whether that's the case or not. But I do know that we do have clients that ring us and say that, you know, either providers won't take clients on or the wait list is months away even to get an intake appointment. And so that kind of puts them in a situation where they need to consider other options available to them.
One of the questions we had early on, which I promised the person would get back to, is they asked specifically your wait list at the moment.
So we commit to offering appointments within 7 days for an intake, and then we allow 14 days for the other party to respond. If we haven't had a response, we try multiple times in that period. We provide an additional 7 days, and then once we've made, if that client is willing to book in, we do that within 7 days, and then we usually book a joint mediation a fortnight out. So the process can take anywhere between 1 to 6 weeks, and we're booked a fortnight out.
Okay, and that's in my experience, that's very quick. That's okay, that's good to know. I'll finish up before we get to the questions, and then, you know, people can jump off if they don't want to stick through that. If you can just summarize what you think, Temara, from your perspective, what the advantages are of mediation as opposed to parties going straight to court, or going to court at all.
Go to court. I think that the advantages are you self-determine. You're making the decision regarding the care of your children or your property and financial matters.
I can't hear you, Temara. I'm not sure if it's just me. I'll just type in the chat.
Very costly to litigate.
Yes,
and when I say, I'm not sure if I just dropped out then.
No, you did, but you're back, so that's good.
But very costly. I'll just keep going. Hopefully everyone can still hear me. I would say, it takes a lot of time to go through to litigate. It's costly, but also it's very hard to effectively co-parent with someone after you've been litigious. You know, at the end of the process, you might have orders in place that the courts have decided is in the best interest of the children, but you and the parent are the ones that have to work through those orders and then co-parent. And I think it's very difficult to do that after you've had protracted litigation with the other person. It doesn't make it easier, it makes it more difficult. The benefits of mediation, that you have the ability to focus on what's in the best interest of the children, that it's a confidential process. It's outcome orientated. So we're here to turn the pressure points or the problem areas into something that's really tangible for parents to be able to then go and effectively co-parent.
I mean, going to court when we're required to draft affidavits for parties and essentially set out their worst version of the other party in document format, and if you end up at trial, which not every matter does, but if you do and there's cross-examination, the chances of coming out of that and being able to co-parent, it just really makes things really, really difficult. What I'll do, if anyone wants to leave, I'm mindful of the time, then we won't be offended, but I'm going to jump into some of the questions for the next few minutes before we wrap up. I will pop again Temara's details in the chat box. Just give me 1 second. And then, alrighty, so let's go to the questions. Someone asked, if they initiate the mediation process with you and the other party refuses to attend, will the cost be the same as if it were the mediation went ahead? Can you hear me, Temara? Can you hear me? I'm gonna go and she's not on mute, but she can't hear me. When you do hear me, Temara, jump in, but I'll answer that question while we're waiting. My understanding is it's not going to cost the same. We're having all sorts of technical difficulties. It won't. Can you hear me, Temara? No, that's okay. So it will cost less if the other party doesn't go ahead and the mediation doesn't proceed. So I'm going to go in and answer the other question. I'm not a family dispute resolution practitioner, but I'm going to answer these as best as I can. I have a Section 60I certificate. So in other words, they've got the certificate, they can technically go to court, but my lawyer says there's not been a significant change in the circumstances in our parenting matter to justify going to court. You'll need to speak to your individual solicitor about that, but generally speaking, I can answer that. If you have a certificate, you technically can go to court, but it doesn't mean that you should, okay? So that's my quick answer of that. Temara, can you hear me yet? No, she's gone. I'm going to go through and answer some of the other questions. What's the best course of action if a parenting plan's made during mediation, but one party consistently doesn't comply with it? I would say, well, I'm always going to say get legal advice, but the other thing to do, because I'm a lawyer, the other thing to do is consider whether it's appropriate to be putting something in writing to the other party, to engage back in mediation again. Like Temara said earlier, you can go back and use a mediation service more than once. What else? Temara, can you hear me? No, that's all right. I'll carry on. If you have concerns that the other party is potentially hiding assets and money, is there a way that you can uncover this? Or is this where a lawyer steps in? So thanks for the question. Generally speaking, in property matters, in family law property matters, there's an obligation that you do what's called discovery or disclosure, which is the exchange of financial documents. You have to do that. And in actual fact, from 10 June this year, the law has been amended that the Act specifically says that you have to do that. So what you would do is set out probably in writing the documents that you are wanting. There's different ways. If you're in court, you can subpoena banks, for example, or superannuation trustees. The real trouble is where you don't know what assets are being hidden, and you might go down a rabbit hole of expense to try and ascertain that. So that can be the real difficulty there. If you have a lawyer, speak to them about it. But in the mediation process, you still have that discovery or financial exchange obligation. You don't have to be in court to have that obligation. So that's what you'd have to do. Now let me go back to the questions. What if one party in mediation wants the child to have a voice and the other doesn't? So we were talking about child inclusive mediation before, and both parties would have to agree for that to happen, okay? The other question was, when can a child choose where they live and how much time they spend with a parent? That question we probably get asked, at least at our law firm, on a weekly basis by at least one client. There's no magic age. There's a bit of a misconception that the age of 12 kids can choose to do what they want, but that's not the case. It's going to depend on the type of the parenting situation, whether there's welfare concerns, what's in the best interest of the child, how old the child is, and their level of maturity as well, because you can have a 12-year-old who's quite immature as opposed to an 11-year-old who's, 8 years above in their age. You can also have a 16-year-old who's going to vote with their feet and essentially do what they want to do. Let me have a look. I'm mindful we've just gone over the time, and I can see that Temara is no longer a formal presenter, so we've lost her along the way, but I still, even though she's not with us, I want to formally thank her for joining us. I've popped her contact details above if you want to get in contact with her. She does help clients anywhere around Australia. So as you heard, she will do Zoom sessions. Her wait times are short, and in my view and experience, she's a very good practitioner. So if you've got any questions directly about mediation, I'm sure she'll be agreeable for you to reach out to her. And she's not here to say otherwise, so I'm saying that on her behalf. Thank you everyone for joining us. I'm so sorry about the technical difficulties that I had, and also she's obviously had as well. I thank Temara for her time. She's a wealth of knowledge. And if you do have any questions, feel free to reach out to myself or her, and we'd be happy to assist. This will be recorded. It's not the best one to watch, given that she was blank for half the time, so you're stuck with me. But thanks so much for your patience. We really appreciate it. Have a great day. Bye.